This, for me, is the biggest challenge I think we're going to face as landlords, and I think we're going to see more and more rent repayment order requests through the courts, and therefore I feel it's our biggest risk if we get anything wrong of our way of being penalised. You said earlier, didn't you, sir, that your tenant is on benefits. And yesterday, just yesterday, I was speaking with a landlord. I was doing a renters' rights risk assessment for his property, and his tenant is on benefits. Now, when a tenant is on benefits and in receipt of benefits, the council already have information, don't they, that you are the landlord, there is a property that's being rented, they know the address, they know what's going on, right? So you're already in their radar before that database comes along. And a rent repayment order can be requested by two people, the tenant or the local authority if they pay the rent. Either one of those people can make an application for a rent repayment order. And over the last few years, there's been success of 75 to 80% in court of rent repayment orders being paid back to tenants. And at the moment, as of up to today, because tomorrow it all changes, the main reasons that people can apply for a rent repayment order are failure to have a licence on a property where it's licensable, so HMO, additional or selective. Unlawful eviction, so you go in, hurl the tenant out and you evict them and then you're prosecuted of it. Failure to comply with an improvement notice, real big chunky stuff, right? Real serious stuff. As of tomorrow, all of that changes. A lot of what we've talked about today falls under rent repayment orders, and the list of reasons why tenants and the local authority can make these has grown quite excessively. And in today's world, the maximum that a tenant could request would be 12 months. And they can do that up to 12 months after the offence has taken place. In the new world tomorrow, the amount is 24 months and 24 months after the offence. So it really, really changes the game and makes us even more liable. So to close, I just want to summarise, because I think I've literally stood here and probably convinced you all to sell. But we are just in a new world, and we just need to learn how to live in this new world. Because to me, the biggest risk to landlords under the Renters' Rights Act, as I said, is not bad tenants, it's bad paperwork. You get something wrong, and that can be more critical to you than any bad tenant. As landlords, you haven't lost your rights, but you have lost the margin for error. You cannot be one of those landlords that says, I didn't know about the deposit protection thing that came out 20 years ago. I didn't know I had to send the PDF leaflet to the tenant. I sent them the link, I'm so sorry. You can't. So we haven't lost our rights, but we have lost the margin forever. And Alicia said it early, this is no longer about owning a rental property. Accidental landlords cannot survive this new world. This is about operating a fully compliant rental business, and you have to look at it as such. And think about what I said about insurance and everything before. As a letting agent, we have PI insurance and all of the relevant insurances that we need to protect ourselves to operate a business. You need to do the same. In the new system, I genuinely believe this, that possession will depend less on what actually happened. You could go in there and actually tell the truth. Tenant didn't pay the rent, tenant didn't do this, tenant didn't do the other, tenant didn't do this. But if you cannot prove it, you're not going to win. So I feel that it's now going to depend less on what's happened, but actually more on what you can prove. The landlords who stay compliant will stay profitable, but the ones who don't will become examples, and they will be those court cases that we're looking forward to that will set the precedent of the new world as we know it tomorrow. So don't let that be you guys. I keep having a joke. I keep saying, oh, imagine the compliance director of Concentric. I'm the first one in court, because I was like, I'm not posting all them leaflets. I'm just going to email it. And then I thought, no, Dawn, you don't want to be the first case law in law. That would look terrible. So no.